Okay, my name is Melissa Martin, and on behalf of the Oregon Coalition for Environmental Rights Amendments, OSERA, thank you for joining us today. We're excited to host our feature presenter, Matt Dos Santos, co-executive director and general counsel at Our Children's Trust. I'm sure anyone who clicked on Matt's bio would be just as blown away as we were regarding the depth and the breadth of incredible, meaningful work they've done for so many. But to summarize, however, Matt works alongside Julia Olson, leading Our Children's Trust, focused on the operational side of the house. Matt has about 20 years of litigation experience fighting for historically oppressed communities and so many others. Previous to their current duties, Matt worked as the legal director for the ACLU of Oregon, where they were nationally recognized as best LGBT lawyer under 40 and received such accolades as the Oregon Gay and Lesbian Lawyers Association Award of Merit and the Richard M. Ginsburg Outstanding Leadership for Immigrant Rights Award, Immigrant Rights Award from the American Immigrant Lawyers Association of Oregon, and the Aguila Award from the Latino Network for amazing work for the Latinx community in Oregon. And before that, the list goes on, but Matt was recognized for their contributions in life sciences and technology, receiving an Angel Award for deep commitment to pro bono work and so on. Before law school, Matt worked as a biologist and conducted environmental impact assessments and endangered species surveys throughout the West. But coming back to today's work, the folks working on the right to a healthy environment were relieved and inspired, overjoyed that Our Children's Trust was probably the first, if not a very early lead partner in this effort. So personally, I'm honored and privileged to be working with Matt on this beautiful challenge. And I can speak on behalf of everyone in OSERA as well. We are lucky to have you out in the front, leading the way during this critical point in our story of humanity, really. So thank you for your life's work. Thank you for your time today. And the floor is yours.
Thank you. And one of the accolades that I don't have is the ability to effectively run a PowerPoint on Zoom. And I don't know that I will ever be recognized for that skill set. So I apologize in advance for the clumsiness of this and will do my best to make sure that this is as sort of easy to see as possible. And like I said, you know, I may not have all the answers to your questions today, but my hope is that I can answer some of them and that we can walk away with a list of questions that might help folks reach a decision point. So if you want to ask questions, please just interrupt me and or throw questions in the chat and we can come back to them. And of course, Mel, I probably won't be able to see the chat because I'm going to try and share my screen, but but you can interrupt me too, just like stop me. Okay, so let me see if I can let's see if I can do step one, which is you'd think I would know how to do this by now. Slideshow. Okay, play from the start. Let me see if I can share my screen effectively. And I might do this, depending on how this works, I might try and just share it in um, not presentation view, but we'll see. Okay. Uh, okay, let's see if this works. Okay, so can everybody see the screen okay? And great, sounds good. So I'm going to go through this really quickly because I don't want to focus too much on our work, but I wanted to give you all an example of how our work has relied on constitutional rights amendments and where we've seen it be really effective in court. So Um, we started our work, our Children's Trust started its work back in 2011. Really, it was founded in 2010, but did its first series of what I will call administrative litigations, right? So rulemaking petitions that were focused on trying to get agencies to acknowledge an implicit constitutional right to a stable climate. So you can imagine back in 2010, conversations about climate change were a little bit different than they are today. I think people are really experiencing climate change in a much more profound way. And so in some ways that kind of the perverse ways that lawyers think about like, oh, this is a great fact. Like one of the good facts in our favor is that many people are now experiencing the impacts of the climate crisis in really tangible ways that they weren't experiencing when we launched our campaign. Um, so I'm doing something that I don't normally do, which is kind of trying to demonstrate the shift in our litigation. And there's a point to this, which is that I really think that constitutional rights amendments can be powerful tools, both in securing climate rights for children and future generations, and really all of us, that we represent children, but that they can have a watershed effect or waterfall effect, a cascading effect on many other approaches, including statutory approaches, and by changing the underpinning system, right, the system by which we evaluate our choices as a government. And one of the premises that I'm going to just throw out there is that while it is very effective, I think, to as both a messaging campaign as well as an accountability campaign to go after major polluters, right, like fossil fuel industry folks. What my sort of like what I will posit is that the we have yet to see a campaign in the United States where going after corporations ultimately results in like a change in behavior. Whereas government has the ability to change corporations' behavior by changing the underlying regulatory scheme that corporations have to abide by. And so that's some of what is underlying this campaign. So this sort of shows some of the like really important things that we did in each stage of the litigation, both in cases where there was an underlying environment constitutional amendment, and in cases or in states where there wasn't at the time. And it shows kind of the progression of our litigation, including what I'll bring your attention to, which is the Oregon litigation and Cherniak versus Brown, where the Oregon Supreme Court really recognized its duty to look at youth constitutional claims, and really, even though we ultimately lost at the Supreme Court, there is an incredibly powerful dissenting opinion that we have used repeatedly, from you know that from Justice Walters, that we think can give us a framework for how this would work in Oregon moving forward, and why we're so excited about working with Osara to try and move this forward. But essentially, and you can see that quote down there. Um, it really, what Justice Walters recognized is that even though it was that the legislative and executive branches are ultimately responsible for a lot of the policy making, that doesn't give the judiciary a pass, right? Just like in same-sex marriage or marriage equality litigation or in desegregation, the courts have a vital role to protecting constitutional rights, both implicit and explicit. And we've been really pushing on that in the context of climate. So what I will say is, now kind of fast forwarding, I'm going to fast forward past Washington and Florida, though I can certainly answer questions about that later. There was an incredible decision in 2023 out of Hawaii, that basically acknowledged the scientific standard that we had been trying to enshrine in law, which is this idea that we have to get atmospheric concentrations of CO2 down to 350 parts per million. What the Hawaii Supreme Court did in this concurring opinion was really recognize another statement that had come out of Oregon, which was out of Judge Ann Aiken's decision in Juliana previously, that the only way that various state constitutions make sense is if there's an explicit or implicit right to a stable climate. Because how do we have those basic promises of that our government affords us, right? Like the promise of life, the promise of liberty, um, the pursuit of happiness, if we don't have clean air and clean water. And so there's these essential promises that we have tied our litigation to in every constitution, whether it's explicit or implicit. But what was interesting about Hawaii, and then fast forward to Montana, which I'm going to spend some time talking about, is that Hawaii does have an express provision to a livable climate, and Montana has an express provision to what's called a clean and healthful environment. The language that we have leaned into is slight, like it's kind of like an amalgam of both, that's informed by our litigation, and we can get into some of those details later. But where we have seen tremendous success recently is in the state of Montana, a groundbreaking win there in 2023 after going to trial and presenting all of the evidence in 2023, and then in 2024, which is not on this timeline. Unfortunately, I just didn't have time to include it, but we reached this settlement with the state of Hawaii, which I think will be really instructive in states like Oregon, where you have a Democrat-controlled executive and legislature that we think do have an interest in advancing policies that decarbonize the future, right? And decarbonize our fundamental systems for the betterment of future generations. So that settlement, is to keep in mind, was reached in part because of the win in Montana and because of their own constitutional provisions. And if you want more information about that settlement, you can go to our website and go to the Hawaii page, which will take you through the timeline. And again, I'm happy to answer questions, but I want to move quickly through this. So this is Held v. State of Montana. Held's composition is very different than ours in some ways, and that they're really an extractive state, right? Like they have one of the largest coal reserves in the world. If you combine Montana and Wyoming, I think it is actually the largest coal reserve in the world. And they were both transporting and exporting so much fossil fuel energy that their fossil fuel makeup looked a lot like countries that were many, many, many times larger in size than they were. So Montana is a population of just over 1 million, but their annual CO2 emissions was the same as the countries of Argentina, Netherlands, and Pakistan. And that had a lot to do with what they their statutory framework, which I'll just talk about very quickly. The Montana State Energy Policy very expressly talked about needing to maximize extraction. I think there's some analogs in Oregon's framework around timber, actually, and we've been looking a lot at how Oregon's legal framework around timber is perhaps unconstitutional. The and Montana had a particularly bad law that said that you couldn't even consider climate change when doing an environmental assessment, which we know is not the case in Oregon. But what I will also sort of posit out there is that the procedural check about just considering climate change without actually tying it to a constitutional right is insufficient to protect our rights. So just saying oh, we considered climate change, but this on the balance is overall beneficial is actually incorrect. And I'll get to how that plays out in the courts. These are some of the constitutional rights. I already talked about Article 2, Section 3, which is a clean and healthful environment. But these were the various rights at play. We presented science by some of the best scientists in Montana and really around the world. And I won't get into all of their testimony, but really the focus on this was to say, like, look, there is an abundance of evidence that right now we are engaged in acts that harm children and harm future generations, and the decisions we make today as a government impact our lives for decades to come. And that's why it's so incredibly important to to tie it to a meaningful scientific standard, and to tie it to a constitutional right that provides, rails for government decisions. I'm going to skip over a little bit of this expert testimony just because of timing, but this was just to sort of show just how bad, right, like our carbon emissions have become in the last 50 years, 60 years, and really how critical it is to get back to below 350 parts per million, and which is really the equivalent of about 1 degree Celsius. We don't really love temperature targets for lots of reasons, including because of the impacts it has on marginalized communities, right? Like the temperature in the Arctic Circle, the temperature increases in the Arctic Circle are about 4 to 6 times what they are near the equator. And so in using a global average is actually exclusive of some of the most impacted communities, like folks living in the Arctic Circle, folks living in Tuvalu, et cetera, like island nations. Um, so I'm going to skip a little bit of this really quickly, but this is a lot of the reasons why we believe that we need to introduce all of this important scientific evidence, and why having a constitutional right really helps us do that. Um, but sorry, I'm skipping through all this IPCC stuff, which I assume many of you are really familiar with. The types of evidence that we were able to introduce in this case, I think, are really relevant to the kinds of things that we're seeing in Oregon, right? So increase in wildfires and impacts on agricultural lifestyles, right? So like Ricky Held, the named plaintiff, was a rancher who lived in southeastern Montana, who had, cows who were suffering from starvation um, and drought, plants, crops that were suffering from drought. And then, of course, just like many, many months of just not being able to leave her home because of wildfire smoke and the pollution, climate pollution in the air. We also were able to introduce the loss of snowpack, right, which has tremendous impacts on drought, but it has other impacts. One of the things that I found so interesting about the way that this testimony was presented was that really ultimately it's not just the decrease in precipitation that matters, but it's the changing in time and volume, right? So like, and this is really important to Oregon, a macroinvertebrate, so like a little bug that might feed salmon fry. If water falls too early or too late, that little bug might hatch at a time when the salmon population isn't there to eat it, which may have downstream cascading impacts on salmon survivability. And so this became really crucial evidence both in Montana, and I think would be crucial evidence in an Oregon case. And in terms of mental health, right? Like we know that now there's just like study after study that shows that children are experiencing climate anxiety at rates that we've never seen before. They understand that the world that they're inheriting is dramatically different than the world that any of us on this call that's over 40 grew up in, and that's having real tangible impacts on their mental health. So like I'm sort of skipping again, sorry, some of these slides, but I wanted to get you some of these findings of fact because I think it's important to see how they're tying back to these constitutional rights. So we had hundreds of findings of fact by the court that were essentially the testimony of scientific evidence that we put in. Everything from psychological harms, as is witnessed here, to the disproportionate harms, right? That are tied to children. So, what's important here in this conclusion of law is that children aren't just disproportionately harmed because children born today might live for 80 years or 90 years or 100 years with climate change and the climate crisis, but because like during those critical years of development between ages 0, like in actually really pre-zero, like while in utero through ages 26, their brains and lungs are developing, and the impacts of climate pollution on a developing brain, cardiovascular system, and pulmonary system can have lifelong consequences. Um, this kind of got to the findings of fact about Montana. Again, I think this would be true in Oregon too. Um, it doesn't matter that Montana's pollution is smaller than China's pollution or smaller than the US's pollution. Like you can sort of see the absurdity in that argument, right? Like every ton of greenhouse gas that's being unnecessarily emitted by a state actor is contributing to worsening climate crisis. And that is exactly what the court found here, was that these emissions are causing and contributing to climate change. Doesn't matter if they're the size of Argentina or the size of China, that they also have a role in the harms that are being committed. Um, and really, this finding of fact is important, right? This is about Earth's energy, and essentially, like the finding of fact that the court, relied on was that until we get this Earth's energy imbalance rectified by reducing the amount of carbon dioxide equivalents in the atmosphere back down to, 350 parts per million or lower, we're going to continue to see a heating world, and climate instability will continue to worsen. Kind of already talked about the Keeling curve and a lot of this actually, but essentially this conclusion of law is so critical to what we're talking about. So the court found that Montana's climate, environmental, and natural resources are unconstitutionally degraded, right? So the court actually said that what you're doing by continuing to permit natural gas transportation, extraction of coal, burning of natural gas, citing of new power permits will further degrade the environment, and it's already unconstitutionally degraded. So, of course, like that leads to, I think, the natural conclusion that any additional permitting of fossil fuel projects, and this is how it gets to that statutory piece, like the things that like a lot of us on this call have fought historically, which is like by going project by project, this helps. So like now we can say like, look, the court has already found that the environment is unconstitutionally degraded. So anything else is going to make it worse. Like we actually have to roll these back until the environment is no longer unconstitutionally degraded. And I mean, I'm really into science, so this is why it's my favorite. It's like really critical that the court relies on best available science, and that without science-based actions, the state is really not going to be able to course correct. I'm going to skip over a little bit of this. This is all stuff we know about, the IPCC. But really, the point of this slide is just to show how, there are many courts that have said global warming of 1.5 degrees is like that's too much, right? Like because island nations disappear, because environmental justice communities suffer the most, it can't be the human rights standard. And I only bring that into this presentation as sort of like a point of information for why we're not using Paris as a target. It's just we have evidence that suggests that using Paris as a target would be inhumane, essentially. I'm going to skip over this. And so I just want to sort of pause and allow us to get into some of the questions here about why this is so powerful. But this idea that the right target and the right framework is really important to our ability to advance environmentally just uh, solutions, I think is my underlying point, right? Like we want to make sure that we're not only advancing politically expedient solutions, but we're advancing a real meaningful solution with a really like a meaningful framework for how to guide government action, because we know government action is going to really underlie the ways that industry behave in our state and beyond. So this is just my information, and I can stop and answer questions now.
Go ahead, Linda, and then Helena.
Matt, thank you so much for all of that. That is a very fast but thorough presentation. You've used the phrase of unconstitutionally degraded environment. And is that in your mind? Has the court found that violating 350 parts per million is that line as unconstitutional?
The trial court did. And so we're currently before the Supreme Court. And I think the rub in that case will be to see if the Supreme Court further narrows the ruling or not. Obviously, we're arguing that this should be a fundamental, not a procedural right, and that the right scientific standard is 350 parts per million. The good news is the state of Montana didn't argue any of the findings of fact on appeal, so I don't know how the court reaches that and their Supreme Court decision. But I just, in terms of timing, obviously, I don't know when the Supreme Court of Montana is going to release an opinion, but what I will say is that we suspect it will come. They release opinions on Tuesdays. We suspect it will come sometime in December, and we'll have a little bit more clarity on what it like remains of the Montana Supreme Court. What remains of the Montana decision after the Supreme Court decides. And we're very optimistic, by the way. The Supreme Court arguments went really well in Montana.
Go ahead,
I
Helena.
think, yeah.
Hi. Well, first, thank you all, and thank you so much, Matt, for your presentation. It was spot on. And with all due respect, as far as I can see, the way the amendment is currently written, it is not either beyond and how it's going through the legislature. It's not either above politics or beyond the reach of profit interests. We can see, like with the California low carbon fuel standard, which theoretically is based on science, but it depends on what science you use, and where your boundaries are for what you consider in terms of life cycle assessment, that it is actually being harmful to low-income communities, and it's also being harmful to the climate at large, from many scientists' assessment. So my concern is, how are you going to stop companies that are promoting solutions that, when they are expanded, such as biomethane or other types of biofuels or biomass energy, that are actually destructive and harmful, but they have the state saying that they are, negative emissions or zero emissions? And how are you going to make sure that a person, a corporation, not a natural person, but a person, doesn't use this amendment to further their profit interests and actually harm communities? Judges aren't scientists themselves, because the companies have a lot more lawyers and a lot more money than the nonprofit folks who have every good thing at heart. So that is my question.
Yeah, that's an interesting question. I think it's the first time someone has asked me, because I understand the first part of your question. I'm not sure if I understand the bridge between the introduction of like sort of false solutions. Like we all know that biofuels are like garbage solutions, at least those of us who work on this do, but I don't understand what the concern is in terms of like how a biofuel company would use the amendment to advance their interests. And maybe if you have some thoughts about that, that might help me answer it. And also I might have to think about it because this is literally the first time someone has suggested that to me. So far, just so you know, like that every time we've brought this litigation, like the RAGA, like the Republican attorney generals and or fossil fuel interests have tried to intervene to stop our cases because they hate this litigation and they hate this idea. Um, uh, and so I have not seen and I can't think of a plausible use by them, which is to say there isn't one.
So let me clarify. If a corporation, a person, sues the state because they, on paper, they have these calculations that they have a negative emissions biofuel, which they do have calculations about that. And they sue the state for not allowing this to go through because it would reduce like greenhouse gases. They, like, as far as I can see, the amendment does not prevent that because it uses I'm not a lawyer. I think there's a difference between person and natural person. I'm not actually sure, but like certainly a person under the US Supreme Court definition, like a corporation is a person. So that is my concern, that these companies would actually start bringing cases against the state.
Yeah, I think the amendment attempts to, that's the idea behind natural personhood. Like the amendment attempts to make it so that corporations can't use it at all. And yeah, and I mean, again, I think this might be an unsatisfactory answer, but I'm not I don't know exactly how they would advance. Like if Oregon denied them a permit for operating because they said, you know, we think that their science is bad. I don't know how you turn around and use this amendment to advance the alternative, right? Like the negative.
But Oregon doesn't currently think their science is bad. Look at what the Oregon DEQ says about biofuels. Look at what the city of Portland says about biofuels. Yeah, I'll stop because I know there are many more questions, but like if it does say person and if it goes through like that, I'm super concerned and I can't support it.
Matt, do you mind if I clock in real quick?
No, go ahead.
Just to share the language regarding what this is, I think some of this can be answered by what it would take for a plaintiff to bring a case under this amendment. They would have to show that there was harm or a threat of harm to public safety and health interests in this right. So that would be the first, I guess, threshold a ne'er-do-well would have to meet to bring a case against the state. But the bottom line is that it is by virtue of this issue being brought into the courtroom, it's a matter of evidence. The rules of evidence will ensure that there will be a battle of the experts, the studies will be presented and cross-examined, and the best available science will be on the table. Okay, so no matter who says what about what, the science will come through in the four corners of that courtroom. So that considered, that also, in addition to the litigation aspect of it, what that does is ensures that there are only certain factors, best available science type caliber of evidence, that will be a matter of policy making. So in addition to the backstop, the legal backstop of proscriptive nature of what this amendment does, it also is a prescriptive promoting good law based on best available science. And the politicians themselves, the agency folks, you know, the government personnel will have best available science standards at their backup to show why they're doing this and that and not permitting that or that and those types of decisions. So it'll be all based on the science. And if there's disagreement in the science and a corporation wants to take this into court and say, this, you know, we have better science, they can bring it into court and the science will be seen. And then, so that's the bottom line. There's, no matter what the politicians say, no matter what the industry interests say, is good. It's a matter of admissible evidence and what the best science shows as the best way forward. So I hope that answers the question.
Yeah, and I guess the only sort of finer point I would put on this is moneyed interests in the United States have an incredibly have like an outsized impact on policy, and we all know that. And we're seeing, like, here's a good example actually, Helena, of what you're saying, analogy, right? Which is we have seen people try to use um, like desegregation cases and cases about racial bias to advance the interests of a white person who feels like they're discriminated against, right? I think that's kind of the underlying thing that you're getting at, is like, how can this be used in a bad way? Um, and what I would sort of say is, like, I don't think we can predict that future, but um, there's lots of evidence that this can be used in a really productive way, and less evidence that it has a path for being used in a negative way. And on the whole, I feel um, confident that that this would provide us with tools to advance environmental rights in Oregon more than tools for industry, and which isn't to say it couldn't happen. Like, I want to be clear that we see how, like, these things get turned, but that doesn't mean that we want to get rid of all, like, race laws, right? Like, we're not like I think people would think that was not the right solution. And so I worry a little bit about um making a decision based on a potential hypothetical negative outcome, that when we have what we see as like a potential useful tool to advancing some of those rights. And you can disagree, like, that totally makes sense to me.
Thank you so much. Anne?
Well, yes, so to piggyback on that, I guess, in terms of science, I mean, it seems to me we're going to be facing a whole new EPA administration that will kind of destroy what we currently know as solid science. So do you feel that's going to play a role, at least for the short term, hopefully short term?
Yeah, and actually, I failed to lead with, like, one of the most important reasons, I think, which is, because of the federal changes that we are going to see, that it is more important now than it has ever been to try and shore up laws at the state level. This is true for every right, not just environmental rights. But it's why it's going to be incredibly important for Oregon's Department of Education to shore up its policies for, like bully. I mean, like, we are going to see an assault on individual rights and freedoms from this administration, unlike that of what we've seen in the past, right? Even worse than the first Trump administration, which is why I feel like it is extra important for us to be thinking about ways to safeguard and protect things at the state level.
Well, I mean, just to that point, I think, for example, the DEQ relies on the EPA's regulations to set its own standards. So I don't know. It gets a little muddy, I think.
Yeah, and where we've seen that happen in the past is sort of to what Mel was saying, but most of the protections at the federal level can be exceeded by state law. I mean, this gets, like, complicated with the Clean Air Act, et cetera, and who knows if the Clean Air Act will survive another round of cuts. But oftentimes what we'll see is that the federal science or the federal law is the starting point, and then states have some ability to regulate beyond that. to meet the needs of their population. That's sort of like a shorthand way of getting into supremacy clause. But at the end of the day, I think that the real tension that you're describing is one that we're going to have to address by simply saying, and where this is going to be true whether or not this constitutional provision is, advanced, right? Like those of us who work on regulatory framework analysis are going to have to struggle with this and say, like, look, one of the benefits, right, of this crazy Supreme Court undoing everything and saying, and this is true for federal litigation. I want to be clear that Oregon litigation and federal litigation are different and unique, but like the undoing of the Chevron doctrine in some ways makes it so that it is a battle of the experts, because now agencies don't get deference. So now it's going to be like extra important for us to say, this is the scientific standard and this is why this is right. And thankfully in the climate space, we really have large levels of consensus around what the best scientific evidence is. And I think, back to Plena's point, like some of this, the junk science that's being advanced about these negative emissions, like you can only get to that number if you do gymnastics, like very hard. And it's fairly like well documented how they're getting to these numbers of negative emissions. And so it's going to be incumbent on us to really argue those positions in court. And I think that's going to be very true, like setting aside what happens with this particular constitutional amendment. And we're going to see this play out quite a bit for the next 4 years and beyond, because this is going to have lasting consequences on how we deal with this.
Tom.
Yeah, I'd just like to follow up on that best idea, because I mean, while we on this call are pretty confident about what the best science is, not everybody is. And so my question's around that, because that's a value judgment. It's not a science judgment, it's a value judgment. Is there a formal, a legal, or any sort of formal definition of best? Or are there any criteria for what counts as best, agreed upon criteria? Are there any, is it clear who, I mean, you would hope a science people would be the ones that would determine or have a say in what the best science is. So that's just my question around the word best and judgments about it.
Yeah, it's a little bit of a shorthand, to be totally honest, Tom. Like there are standards that courts use. I'm trying to think of what the language is like. There's like is it clear and articulable set of standards that are easily followed, something like that. There are ways in which different expert evidence gets weighed. And what that shorthand that we use around best available science is really to get to, like, we're not talking about political compromises. We're talking about current scientific consensus. And the way that we advanced that in Montana, which I sped through that presentation because I knew there would be lots of questions, which was to show, IPCC, right, which is literally consensus science, which, thousands and thousands of pages of leading scientists, right, like surveying the field and coming to conclusions to the best of their ability. And we just kept going back to that stuff and showing all of the consistencies through that, those decades of scientific evidence, and how the state's position was completely inconsistent with it. And so it is about using consensus science available to us today. And in that idea, and I understand all of our fears around how the Exxon Mobils of the world and the Chevrons of the world have injected doubt into science. But what I will say is that in my experience, that's not the fight that we lose in courts, right? Like courts understand that they have to weigh all of the evidence and come to a conclusion about what is most persuasive. Where we have struggled in courts is around basic, like whether the courts have a should even be involved in this, or whether it's like a total policy decision, whether children or any of us on this call have standing, meaning like, do we even can we articulate a harm? And what we've said is like, no, that's garbage. Like, we don't have to point to an individual molecule of carbon causing this cancer, or causing this respiratory disease, but that the aggregate acts of these polluters, advanced by permission of the government, is sufficient to show causation to the harms. But those are the fights that become really, really a struggle. And it's why we really believe that advancing constitutional provisions like this could help us win more in courts.
So are you saying that there really isn't that much actual disagreement about what counts as best available science in courts?
When we present it to court, in our cases, and when we've presented it to courts, even actually in not our cases, but cases we've consulted on, you can look at the European courts, they do a pretty good job, especially the constitutional courts, of taking like a very hard look at all of the science that is presented by the parties, and have, in almost every single case that I can point to, concluded that the science that we've presented, or that like our allies have presented, is the best available science. So we have not seen courts hung up on whether climate change is real, or whether carbon dioxide is driving global climate crisis, etc. Sorry, I see a lot of other questions coming up.
Linda? You're on mute, Linda, sorry.
I'm sure, Matt, you're aware that we are about to storm the Capitol, both in December as well as next year. Can you give us a sense of how many of the Oregon youth plaintiffs might join our cause, and any other plaintiffs from these cases that could come and speak to legislators this coming year?
Oh, yeah. I mean, I think that the young people involved in our cases would be happy to join as they can. Like, obviously young people are often in school and whatnot, but they've all expressed a desire to be involved in long-term policy changes that would drive these results. So I have no doubt that we will be able to engage with our young people, and they're currently actually forming like a youth council for our organization that I think would help drive some of that, lobbying days kind of efforts.
Great.
Anne?
Yeah, so my kind of follow-up question is, if if there were a suit brought against this, and it became part of Oregon's constitution, does the federal Supreme Court have any standing in reversing it?
It's very, very, very hard for the Supreme Court to reach a state constitutional provision. I have theories about how that might play out with this particularly pernicious SCOTUS that I'm not going to put into a recording. I don't want to give anybody ideas, but I know what I would do because I think about how to win these cases. But no, I think it's really, really hard. And this is why you're seeing reproductive movement try and enshrine abortion rights in state constitutions, why you're seeing same-sex or marriage equality rights being enshrined in constitutions at the state level, because it is incredibly hard for them to reach state level rights.
Great, thank you.
Thank you. Jared?
Howdy. Thanks for the presentation and answering questions. This has been great. I wanted to ask just on, we have a lot of environmental issues across, planetary boundaries and overshoot limits in different ways. And I'm curious if you could speak to how courts may look at that breadth of concerns. For example, like if someone goes to a court and being like, we're going to argue for using biomass fuels because it does some, gymnastic carbon mathematical thing, but they account for like the biodiversity loss and just how well do courts handle the systemic perspectives and the science? And I'm curious if you could speak to that.
That's an interesting question. It's sort of like it requires me to kind of characterize the different holdings, right? I don't think, say, how do I answer this? And I'm happy to have like a more in-depth conversation with you about this, Jared. I think we have not advanced biodiversity loss in as aggressive of a way or as squarely part of like the main features of our cases as we could. And so I don't think courts have dealt with it head on, except in a couple of instances, most of which have been extra US. So like the cases that I know of that are, meaning outside of the United States, the cases that I know of that have dealt with it in sort of like South America, et cetera, um, have really, I think, dealt with it pretty well, but they're outliers. And I think that we do need to think about how to look at some of the bigger systemic issues. The tricky thing with the United States is that so much of our litigation, and this is why I always say this too, like litigation is just a tool as part of like the toolbox that we want for solutions. It's not like a magic pill. Like I don't think we're going to litigate our way out of this problem, but it can provide us with some frameworks for guardrails that can help us advance solutions that are going to require some really hard policy muscle too. And I think the biodiversity piece is one of those pieces that we have to get better about sort of centering and messaging on.
Thank you. Kim.
I've had the argument come up that it's better not to attempt to amend the Constitution because that opens it up to amendments that might not be desirable. This was coming from a Democrat, alluding to the idea that other parties might amend it in unfavorable ways. What would be a good argument back to that kind of retort?
Yeah, so I mean, I think the simplest argument to that is like freezing our constitution in time doesn't make a lot of sense. It should be a living and breathing document that addresses the concerns of people today, and that our constitution is inadequate in addressing the climate crisis. And they're not, I would say, like, you're not wrong, right? But advancing a climate and like advancing a constitutional amendment is not easy, right? And part of the reason why it takes so much time and energy and organizing to do is that it is not easy. So they would need a majority of legislators to agree if they were going to do it through legislative referral, and really like more than a majority. Like they basically need everybody in whoever controls the House to agree, and then if beyond that, then they need to convince the population to vote in favor of it. So like it is a we have seen that tactic used against same-sex marriage, right? I worked on this a lot when I was working on the ACLU and before. We saw amendments advanced at state levels to restrict the rights of same-sex couples to get married. And they had to undo that afterwards, after a big fight, but it is not impossible. But I, again, would say that doesn't mean we should just like freeze the Constitution in time. That just doesn't make sense to me. And I think it results in more harm, and in no way protects us. I should do some writing about that, actually. That's a good, I like that question, Kim. It's interesting that people would suggest that, especially from the Democratic Party, because you can point at like, okay, great. Well, so you think we should get rid of like the 14th Amendment, the 13th Amendment, because you can amend the Constitution to abolish slavery, you should not do it, because then people could amend the Constitution to reinstate slavery.
Right.
That's like a strained argument.
Thank you.
And I thought I'd just dovetail real quick. We're talking, I think from what I'm hearing is we might be talking two different constitutions. Of course, you don't
Yeah.
need to open up a constitutional convention for the state before we can amend the Constitution in Oregon. For the US Constitution, yes, it'll, take, I think, 2/3 of the states to vote in, and that would be a Pandora's box. And that is something that I think has been discussed at the national level of this movement. So, but yeah, we're safe. We're safe in Oregon.
This was Oregon, and she's actually works on legislature for the Democratic Party. So I would like to be able to reply in a more effective way than I did the first time it came up. Thank you.
Of course. It doesn't open.
Yeah, maybe we should talk about that, Kim, about how to frame the messaging of your reply, because I find that to be, I would like to help you with that.
Well, this is terrific. Any other questions? Any residual thoughts? Or Matt, would you like to speak on just to close us out, I suppose, a call for support and, especially priority support for the right to a healthy environment? I'll let you think about that while Jared asks this last question. Go ahead, Jared.
Howdy again. I just wanted to, closing thoughts, mention we were talking about the systemic issues, and I just wanted to, I guess, point out the work on planetary boundaries and being able to use that in as best science arguments to kind of maybe more incorporate some of the complex issues in the law cases. But yeah, just closing thoughts on that was all I had.
Yeah, I would love to talk more about that, Jared, because I think that's interesting. And like I said, I think there's ways that we can improve what we're doing. And so I'm a little bit late to another meeting, and I'm sorry, but I will say that it feels very clear to me, after a 15-year campaign to advance the rights of children and future generations to a stable climate, that a constitutional amendment would be an incredibly important bellwether for the state, and that I see it having a waterfall effect on all of the work that we do, both in organizing, because young people need to have hope for their future in order to stay engaged, and giving them a way to advance a right that protects them, I think is a way to re-engage youth that may be disconnecting out of despair. But I also think it has a really meaningful practical impact on our ability to argue at the statutory level, not just complex constitutional civil cases. I know we only had an hour and there's probably a lot to discuss. So I just want to, say that to the extent that there are concerns or people have ideas for how to get more of OCN behind this as a priority, I'd love to talk to you about it. I know Mel would too. Anybody really on Ocera probably, because we really think that this is an important tool that we should put into our toolbox. And I just really thank you all for even getting, I know we're all very busy, so thank you all for your time and questions today.
Thank
Thank
you.
you so very much. And with that, I'll go ahead and close this out. And if anyone has any questions or concerns, please, again, follow up with us at team@oceraunited.org. We're happy to answer anything or have a presentation with whomever. So thank you all again, and have a lovely rest of your week.
Bye-bye.
Bye-bye.